Hello, everyone, and welcome to Reject Modernity, Embrace Tradition, the show where Megan and I take you back to the good old days, just probably not in exactly the way that you might expect from our title. I am, as ever, Clayton Becker.
And I'm still Megan Cox.
And Megan, what are we going to talk about today?
Well, today, Clayton, we are rejecting constitutional stasis and embracing constitutional change.
All right, what does constitutional stasis mean? That's another one of those things that's not a term of art. We just made it up.
Yes, yeah, we're making it up. We're throwing around the big vocab words. You know, last week we talked about heuristics. Today we're talking about who knows. So what do I mean by constitutional stasis? I mean, quite simply, a lack of change to the text of the Constitution. We don't amend the Constitution very much. Now, a frequent observer of the Supreme Court or constitutional law will say, but constitutional law changes pretty frequently. Yeah, it is definitely possible to see changes to the interpretation of the text. Given our institutional structures, it's much more easy to change the Constitution in that way. What I am talking about is changing the text of the Constitution itself, which changes very infrequently relative to our peer countries.
Yeah, the United States, I think actually like right now, you can correct me on this if I'm wrong, Megan, but the period of time between, was the 27th Amendment is the last one? The time between the 27th Amendment and now is the longest period of time in American history without a constitutional amendment.
It is either from right now to the 27th Amendment or possibly
the 13th to the 12th.
The 12th and the 13th. Yeah, exactly. Yeah. I would have to do quick math. And as we know, I should not be allowed to do math on the fly. But this is about as long as we ever go without a constitutional amendment. And we'll talk a little bit more about that 27th Amendment shortly, but I would almost take us back to the 26th as the last real substantive amendment.
Yeah, because the 27th is like congressional salaries, right?
Yeah. It's if you vote to increase your salary as a member of Congress, you don't actually see that increase start happening until after the next election. So Congress can't just jack up their own salaries unilaterally. And that measure was first introduced in the late 1700s. So that's something that we've been talking about doing for the entirety of the Republic. Basically,
and if I remember right, the reason that it got back around to actually getting passed was because like some student was doing a project on it, right? And found that there was no limit. There was no
end date.
Yeah, there was no end date. And he was
I'd fully believe it. Yeah. So for the students among us who are listening, you can have a real impact on the world around you.
You can.
But let's talk about this stasis concept a little bit more, because it is a different concept from longevity, or scholars may sometimes refer to this as constitutional survival. Although the two are connected, as we'll talk about. The U.S. Constitution's longevity, we're coming up on almost 250 years. It is such a long-living constitution that when scholars study determinants of constitutional survival, the U.S. is often excluded from those studies as an outlier because it screws up all of your statistics. Contrast that with France, which has had 16 different constitutions over nearly the same time frame.
Everybody knows the French love their reforms, reforms for reform's sake, man.
I actually, as I was doing the research for this episode, I ran into a joke online. I assume from like the mid 20th century. A guy goes into a library in Paris and says he wants to see a copy of the French Constitution. And the librarian says, "I'm sorry, sir, we don't stock periodicals." So apparently there was a time when this was a very frequent thing that they were consistently redoing their constitution. So you can have that sort of flux in your constitutional text in the whole document, or you can be doing amendments to a broader structure that remains unchanged.
Yeah, and to be clear for everyone listening, what Megan said there is the French Constitution itself, like the actual framework of the document, there's been 16 of them.
16 different ones.
Not 16 amendments, right?
There have been 16 whole different constitutions.
Yes.
But then the U.S. Constitution is also relatively unamended compared to peer nations. So contrast the U.S., which has had 27 amendments over 250 years, with India, which has had more than 100 amendments since independence in 1947. So that's approximately one amendment per decade for the US and one amendment every 8 months for India.
And also in the US, those like that average obscures that a lot of this happens in bursts.
Oh yeah.
Right?
Oh yeah. There's some big ebbs and flows, and we're going to talk about the period where you see a lot of amending. We've got the first chunk is the Bill of Rights, and that all happens at the same time. We've got the Reconstruction Amendments, 13, 14, 15 kind of happening in a tight time frame. And then more amendments happening in the early 20th century. Neither approach, I want to say, India versus the US or the US versus France, none of these things are right or wrong. They come with trade-offs. So we're going to be talking about what I see as the potential trade-off to the unamended state of our Constitution, and how that can create problems and why we might want to think about doing things a little bit differently.
Sounds good to me.
Yeah, we talked about the most recent constitutional amendment ratified in 1992 to the U.S. Constitution, originally introduced in 1789. Prior to that, the most recent successful constitutional amendment was enacted in 1971, and that was lowering the voting age to 18 from 21, which it previously had been.
And that's largely a reaction to Vietnam, basically.
Yep, exactly. I had a lot of fun with this episode going back through each of the amendments and trying to figure out what was the thing that made it happen.
Yeah.
Yes, it was a lot of fun.
This could be interesting, Megan. Do you have like a taxonomy of amendments you might be able to give us?
Clayton, I do. Yeah, because they fit into really easy categories, and we can see not only the taxonomy, but we can also see a time period where
Yeah, absolutely.
we were clearly very comfortable with amending the Constitution, and it was happening a lot. But sort of the taxonomy of amendments, I would give you three categories. Category number one is a problem with the original framework. Something isn't working and we need to fix it. Category number two is social change. The world has changed and we need to keep up. And category number three is the Supreme Court got it wrong. And it is a very clear response to something the Supreme Court has done. So category one, there's a problem with the original framework. You have things like the 12th Amendment, which was electing the vice president as kind of a tag-along ticket mate to the president.
Right, because originally the second vote getter got to be the vice president. Yeah.
Which really they needed to have one election where the first guy and the second guy hated each other, and that would be Thomas Jefferson and John Adams. And you go, oh, this obviously doesn't work if you've got the second guy who hates the first guy running the Senate. That's a terrible plan. So that does come in 1804 when Thomas Jefferson is president. Then you've got the 17th Amendment, direct elections of senators. That comes in 1913. You have the 20th Amendment, which has presidential terms starting in January rather than March. That comes in 1933. Now, you can see why that made sense when it took weeks and weeks to get from Springfield, Illinois to DC or whatever. But in 1933, it doesn't take as long to get places. Also, you have a massive policy shift from Herbert Hoover to FDR in the 1932 election. But Hoover keeps trucking along with his policy preferences until the end of his term, which causes some pretty significant economic harm to people. That it really does cause harm. So there's an amendment very clearly in response to.
And you could argue that like we should maybe shorten that time even further nowadays, right? Like the United States has the longest lame duck session, I think, of any sort of major democracy in the world.
I don't know that, but I would believe it. And yeah, I mean, I part of me thinks, oh, but you need time to do that transition. But also, what is going on in that time frame? You know, so 22nd. Just continuing on this category, the 22nd Amendment, presidential term limits, is a response to FDR serving 4 terms or being elected to 4 terms. The 23rd Amendment gives Washington, D.C. electoral college votes. The 25th Amendment in 1967, presidential disability and succession. I think people were much more aware of the possibility for both presidential disability and assassination at that point. I'm a little surprised that didn't come after President James Garfield was assassinated, because he lingered for like weeks.
Yeah,
didn't
or
he?
after McKinley, right?
Yeah, yeah. So like, yeah, that, but the 60s, apparently people were much more top of mind about making sure they knew how to handle situations like this.
It's a little funny that we had all of the presidential assassinations before that amendment was passed.
Yeah, I'm going to think about that, actually. That's going to stick with me. Anyway, all right. Well, so there's that. We fixed it, though. We fixed it.
We fixed it. If it happens again, we're prepared.
God. Jeez, please, Secret Service, don't come talk to us. So the 27th Amendment. So if the FBI comes, I want you to understand, Clayton, I'm not your lawyer. I'm a lawyer, but I'm not your lawyer. And then you've got the 27th Amendment, which, as we've discussed, congressional salaries passed in 1992. Mm-hmm. So there's a problem with the framework. We have come to realize that there is a particular issue that we need to deal with, and we fix it. Social change amendments are responding to kind of changes in how society is operating at that time. So you've got the Reconstruction Amendments that deal with a legal framework that no longer recognizes slavery, and in fact is taking steps to reverse the prior trends or the prior laws that use slavery or embrace slavery. The 18th Amendment, Prohibition, passed in 1919. There's also, of course, the repeal of Prohibition in 1933. We might consider that there's a problem with the framework, but I did kind of lump it in here as a social change. Hey, we tried this. It's tried to embrace this social issue, but it's not quite working.
I think that's right. The temperance movement sort of... Public opinion turned very quickly against prohibition after it was enacted because it worsened organized crime.
Yeah. There are a number of reasons that the Prohibition Amendment didn't work, but the idea behind it was not completely incorrect. I would also say that that prohibition could also kind of get slotted into the Supreme Court as wrong category, because at the time, the federal government would not have been able to ban the sale of alcohol because of how the Supreme Court was interpreting the Commerce Clause at that point in its history. Mm-hmm. There's that. 19th Amendment, votes for women. 26th Amendment, votes for 18-year-olds. These are recognizing a difference in who we think should be part of our political body, who should be participating in political society.
Yeah, who gets to be part of the polity, basically.
Exactly. So those are our social change amendments. And then we've got the Supreme Court is wrong amendments. I think that we might have a sense, especially if we listen to the justices or the op-eds that they may write, that this is extremely confrontational of our forebears. I don't know that that's necessarily true, but we have the Supreme Court is wrong amendments. The 11th Amendment, which prohibits suits against states from citizens of other states in federal court. This overruled Chisholm v. Georgia, which basically said the opposite, that citizens of a state could sue another state's government in federal court. This is another early 1800s amendment. It might even be easier. It might be earlier. It might be 1790s. For some reason, I did not put the date in my notes, but it's a very early, it's the 11th Amendment.
This is the first one that's not the Bill of Rights.
Yes, exactly.
It's Congress saying, hey, Supreme Court,
Yeah. And note that with something that early, the guys who wrote the Constitution are still bopping around.
In many cases, they're still the guys who are voting on and ratifying the amendment. They're not just bopping around.
Yes, they are the guys. I tell you what, Clayton, it is a weird thing. From my work in Palau, I was aware of, though not party to, constitutional litigation about what the Constitution meant, and the litigants were signatories to the Constitution. So you get the Chief Justice of the Supreme Court saying things like, with all due respect to Counselor so-and-so, I know that you were there, but this is not, you don't get to say what it means, even though you were there and you signed it. It's a very weird situation. So that's the 11th Amendment. We have two more of these Supreme Court is wrong amendments. The 16th Amendment in 1909 permits income taxes in response to the Supreme Court striking down a federally implemented income tax. I'm not going to get into the weeds on what kinds of taxes are permitted via the text of the Constitution. Just know the Supreme Court said we couldn't have personal income taxes at the federal level. And then the Congress and the state legislature said, hey, we actually would like to be able to have income taxes. Given the size of the federal bureaucracy as it grows, it was the only really effective way to fund it at that point. And the final amendment in the Supreme Court is wrong amendments category is the 24th Amendment, which includes abolition of the poll tax. The Supreme Court held in Breedlove v. Suttles and Butler v. Thompson that poll taxes were permissible, and the Congress and the state legislatures, including state legislatures of former Confederate states, decided that they wanted to institute an amendment that would prohibit poll taxes. So those are the amendments.
I might honestly add at least the first clause of the 14th Amendment to this, the Supreme Court is wrong amendments.
Yeah, okay. Yeah.
Like, it's a direct response to the Dred Scott decision.
Yeah,
right?
okay. That's a fair point. That's a fair point.
And I think it's unfortunately once again relevant in our current political moment. For those who aren't aware of what I am referring to, the first bit of the 14th Amendment says that everyone born in the United States and subject to its jurisdiction is a citizen of the United States. This was a direct response to the Dred Scott v. Sanford decision, which held that Black people could not be citizens of the United States. Nowadays, we have one political party, one leader, who I'm sure you guys can guess who that is, that's been talking about ending birthright citizenship.
Yeah, the problem with that is it does require a constitutional amendment.
It does require a constitutional amendment, right? So I think that, like, just to bring it back out of this taxonomy of amendments, there's this there's this tension between constitutional interpretation as a method of constitutional change and just directly amending the document as a method of constitutional change. And I don't think that either side of the debate, the living constitutionalists or the originalists, really hold to one or the other most of the time. I think I'm of the opinion of the judicial realists in political science that they sort of like look at what is advantageous for themselves at the time, and then they make the decision that achieves the policy goal they want to achieve. So, Megan, with that in mind, why is this norm still bad? Like, why is the fact that we don't amend the Constitution very often still bad?
Yeah, I think this is a good way to think about it, because you have just outlined a scenario that I think a lot of us would have some concerns about. I think a lot of us embrace the concept of birthright citizenship and find it valuable. Full disclosure, I am the child of an immigrant. I would like very much to see how many generations of Americans both your parents have to be an American citizen under the forthcoming potential Trump plan. I think, first of all, just to back up a second, I think we must consider that we do have a norm, and whether we whether the norm is just a function of how hard it is to amend our Constitution, or the norm exists independently.
I see.
Doesn't really matter, because we just don't amend the Constitution.
Whatever the reason behind it, it just doesn't happen very often.
Yes, exactly. I think we embrace it as a norm, and we don't talk about constitutional amendments very frequently, because as you and I are discussing the potential constitutional amendment abolishing birthright citizenship, not only are we reacting, I think, to the underlying policy goal, which we don't like, but also the idea that, oh my gosh, they're going to amend the Constitution to do this. That seems really extreme. But yes,
and very final as well, right?
Yes,
This idea, like, because of this norm of constitutional permanence, constitutional stasis, that the Constitution does not get changed except for extremely worthy scenarios, perhaps we say, right? For extremely good reasons.
Yes.
If you then change the Constitution to do something like eliminate birthright citizenship, that feels very final. It
won't get changed back.
Yes, exactly.
Yes. Yeah. Okay. So we are going to talk about all of this. Why is this norm bad? It transfers the role of changing the Constitution to the courts, which then really elevates the role of Supreme Court litigation but at the same time, Supreme Court appointments. It is a constant theme on this podcast that we are down on the Supreme Court. But this isn't necessarily a matter of me or us not particularly liking the current constitution of the court necessarily. It is a desire to see the court as a co-equal branch.
Yeah.
And this norm concedes a check on the courts.
I think that I said in maybe our judicial overreach episode that one of the key problems I see nowadays is that the Supreme Court has seemingly anointed itself atop the constitutional system rather than as being part of the constitutional system.
Yes.
And a big part of this is that we haven't done one of these, like, we haven't done a significant problem with the framework or a Supreme Court is wrong amendment in more than half a century at this point.
Yes, exactly. The people who, I mean, I would have to go look this up, but I'd love to see a head count on who of the key activists pushing that 26th Amendment are still with us, and still active in politics, because you lose that appreciation of constitutional amendments as a tool. Right now, the only tool that we seem to have when it comes to constitutional interpretation and change is Supreme Court litigation, impact litigation at the Supreme Court level. And it seems so fraught because it does seem to be the final word on understanding the text of the Constitution, defining rights, defining powers. If the Supreme Court isn't impeaching justices, which it really doesn't do, or changing the Constitution, which it really doesn't do, then the court does functionally have the final word on the interpretation of the existing text. And in a constitutional framework that is built on checks and balances everywhere else, it seems unlikely that the Supreme Court is supposed to have this much power and that that's sustainable, right? It doesn't seem like it would be.
We've gotten ourselves into this situation where there really are no longer any checks and balances on the Supreme Court, insofar as there ever really were in the first place.
The check on the Supreme Court appears to be death.
Yeah.
And again, not advocating. This is just an episode where I ask the Secret Service to come knocking on my door. We're not advocating any sort of taking that in your own hands. But we'll leave that to the John Grisham novels. But if the only way that you see turnover or change in the perspective of the members of the court is through death or retirement, then you are going to see very, very slow change. And the reason this is important, I read this really great article by Tom Ginsburg. He's a professor of political science and law at the University of Illinois. And he did a study of longevity of written constitutions. And what he found was that for written constitutions to endure, to continue to go on serving as the constitution of a country, they need adaptability, either through the amendment process or through the possibility of reinterpretation. And the level of flexibility varies depending on factors like how responsive or inclusive the institutions were when they were created, or how quickly society or technology or the environment are changing. But the reason that interpretation or amendment being interchangeable in terms of granting that flexibility is important is to bring us back around to the problem of originalism.
Yeah, if you have a philosophy that holds, as Scalia used to say, that the Constitution is dead,
yes,
then you don't have that flexibility in interpretation or in amendment.
All of your flexibility has to come from amendments, which to Scalia's credit, he understood that and embraced that as part of his judicial philosophy. I can remember reading a Scalia, I think, concurrence in law school. I went back and tried to find it and I couldn't, where he said very specifically, the text is not living. The text means what it meant when it was written, and that's all. And if you want the text to change, you amend the Constitution. And everybody in the room, as we were discussing this case, is just like, oh, God, really irritated with Scalia because it seems so impractical, so unrealistic. The opposite of judicial realism to say that, oh, you could just go amend the Constitution. No, it's hard to amend the Constitution. You are setting out what the outcome is going to be by saying this is the appropriate path.
If your argument is, let's do the thing that won't happen, and that's how this
Yes.
will work, then
Yes.
that's not really an argument about how it's not really a good faith argument.
No, it's not, but at least it's intellectually consistent.
At least it is intellectually consistent. You have a point there.
It could be both bad faith and not intellectually consistent,
That's
and that
fair.
is truly the worst.
That's true.
Oh, how our standards have fallen. So that's really the issue that we run into here, where we collectively stop thinking of constitutional amendments as possible or a legitimate or worthwhile mechanism for change that we should be pursuing, but also you can't take anything to this Supreme Court and get the result that you're looking for in terms of progressive interpretation of the law that carries on changing with society.
Or even just like necessary interpretations, right? Like as we talked about with like Chevron in previous episodes, right? Like you simply have to be able to have some sort of regulatory apparatus. You have to have the ability of federal agencies to write rules.
Yes.
And to their credit, the Supreme Court did not go as far as to say that you cannot have federal rulemaking. But I wouldn't exactly put money on the Supreme Court not saying that in the future.
Yeah, it's baby steps. We got to get there. It's like a frog in boiling water sometimes.
Yeah. Well, I think so. This all has, I think, made a great deal of sense to me as someone who comes into this as a non-lawyer. It's made a good deal of sense about why this is a problem, how we've shifted away from amending the Constitution, if not regularly, at least semi-regularly, and why this needs to change. Maybe we should take a bit of a break, and then we'll come back and we will talk about what exactly embracing constitutional change means, and given our current political moment, maybe how do we actually do it?
Hello and welcome back. When we left you, we were discussing how really we need to take back the Constitution from the judiciary, honestly. I want to take us to the second half of this episode, which is where, having rejected constitutional stasis, we begin to embrace constitutional change. So I am proposing, Clayton, that instead of granting sole responsibility for constitutional interpretation to the court, it should be reclaimed by the elected branches of government through the amendment process, which can clarify or modify the Constitution as appropriate. And that is going to require us, the people who elect the elected branches, getting comfortable with change, maybe disposing of the idea that the Constitution is either divinely inspired or the pinnacle of human wisdom, and to a certain extent being okay with mistakes and being okay with changing the proposals that we've enacted.
If I can pick up on the second thing you said there, Megan, about doing away with this idea that the Constitution is divinely inspired or the pinnacle of wisdom.
Yeah.
So on the first part of this, like, I think it is pretty obvious if you look at history that the period of time, like between the 7 Years' War and the start of the 19th century, basically the least like overtly religious time in American history. Like, don't just take my word for it. I went and I got the book. I'm citing my sources here. The book These Truths by Harvard historian Jill Lepore. I think she argues quite correctly that like this is before the Second Great Awakening. Megan, you were mentioning during the break that like Thomas Jefferson, owner of multiple different copies of the Quran,
right? Yes,
he did not believe that he was being like divinely inspired by God to write this document.
No.
And then
very much a deist, very much hands off.
Yeah.
The idea that the Holy Spirit was speaking to anybody individually in such a way was really very much a Second Great Awakening thing. That's a Pentecostal or a Latter-day Saints kind of concept that really you don't see a lot of in the framers. You don't see them adhering to something like that.
Yeah, on the topic of deism is essentially the philosophy, so to speak, that God is real and created the universe and everything, but then sort of took a step back afterwards.
So y'all do what you're going to do.
Yeah.
My work here is done. See you when you're done.
Just is very different from the sort of like model that a lot of evangelical Christians have today. And then also there's obviously just the fact that like the Constitution has changed a number of times since we first did it. Like at the very least, I don't think that we can argue that the guys who were amending the Constitution in the 60s or in 1992 about congressional salaries were divinely inspired to do so.
Not a universal position. I know there are some people who believe that Donald Trump is divinely inspired. I feel as though that might be news to him, but yeah, no, I'm not thinking that Newt Gingrich was filled with the Holy Spirit, or certainly there were times when he was not.
Yeah. And then as to the sort of, at least the original constitutional framework being this pinnacle of human wisdom, I am quite tired of people lionizing the founding generation in this way. Like the idea that they were brilliant or like singularly brilliant men seems a little bit questionable to me, considering that one, they themselves amended the Constitution a couple of times after having realized that their initial system of let the guy who gets the second most votes run the Senate didn't work very well. And then also that they couldn't quite get the right answer to the question of, are black people people? And even aside from that, like you see this in basically every other field, that like even a guy like me who took high school physics as his last like foray into physics, I know more about physics than even someone like Isaac Newton did, just because collectively, as humanity, we've learned a lot more about it since then, right? Like,
in what other field is the idea that the guy who did it first did it best really held on to like this?
Literally, maybe only just like pure mathematics or something like that, right? Like old mathematical formulas and stuff that haven't changed. But
it's like, that Pythagoras, we really appreciate him, you know?
In literally no other field is the idea that like we haven't actually advanced human knowledge quite as prominent as when it comes to like democracy and democratic theory. Like we just know a lot more about how governments work and how they should work than the founding generation did. Like we just simply do, right?
We have more data. We have so much more data.
I think a really good case in point of this, so I don't want to rant at you guys for too long here, is the founding generation did not see political parties coming. Didn't see them coming. Which makes sense given their historical experience.
Yeah, it really does.
And they thought that the system that they were setting up would be the system would avoid the emergence of political parties, as they called them at the time. It would avoid the mischiefs of faction.
And then fucking immediately,
and immediately, all of them ended their lives as the heads of major political parties. And we know today from decades and decades of research on voting systems that the system that they set up is actually the most likely system in the world to produce stable, durable, extremely hard to change two-party political competition. We just know this at like a mathematical level, that this is what the system that they set up mathematically trends towards. And so I think when we talk about embracing constitutional change, a lot of it begins with understanding that the founding generation didn't, in fact, have it all figured out. And like, we can make improvements. We can make improvements to their system. There's no reason to valorize the Constitution in such a way that you think it must be unchanging, right?
Yes.
Like, it makes sense, as we talked about earlier, that we would think about constitutional change as like a big step, a sort of final step in a lot of ways to dealing with a certain problem, like dealing with the issues over income taxes, for example, that was put to rest by Congress and by the various states saying that we can now have individual income taxes, right? It's in the Constitution now. It's been put to rest. It makes sense that we'd see that as a big and as an important step. But we don't have to view it as being like the only possible. We don't have to view it as being only possible when literally every other avenue has been exhausted. And we've been dealing with the results of those avenues being exhausted for a decade, 2 decades, right? We don't need to treat the Constitution as this necessarily unchanging document.
Yes, I obviously agree, and that's why we're doing this show. I think the federal Constitution should be flexible in the way that state constitutions are. If you're not someone who's super familiar with or keyed into the flexibility in state constitutions, just look at the last election here a few weeks ago. We saw multiple states considering amendments to their state constitutions that would protect abortion rights. I think it's particularly funny that Wyoming already has a constitutional provision that effectively does protect their abortion rights, because they had a constitutional amendment in response to Obamacare death panels. You remember that thing that didn't happen, was never going to happen? But they have a healthcare autonomy constitutional amendment in their state constitution already. Oregon, for example, has amended its state constitution more than 260 times since it was ratified in 1859, and not all of those amendments are winners. Some of them are dumb. Some of them are not inclusive. We accidentally abolished zoning one time, and then
sounds good to me.
Yeah, it was subtle, and I get why people didn't realize that's what was happening in terms of the incentive structure that it created. But later, we removed that amendment from the Constitution. We also still have a constitutional amendment banning gay marriage in our Constitution. So if Obergefell is overturned, that returns to constitutional law. I'm sure that would be removed if.
And California just got rid of our amendment that said that marriage was between one man and one woman. So the point that we're trying to make here, I guess, is like there will be mistakes made probably if we do something like this. But by making the Constitution more flexible, it basically turns out all right. Like there are problems as a result of the sort of flexibility of various state constitutions. But I don't think anybody really argues that like the basic fundamental structure of California's constitution is
illegitimate,
or conversely that it is divinely inspired and therefore must never change, right?
Also true, yes.
Like the various state constitutions in the United States are much more flexible than the national constitution is, and quite frankly, it's worked out mostly fine. And I think that this is
not all winners.
Yeah, but this is the flexibility that we should bring, I think, to the national constitution. As Megan was talking about earlier, like it's become a national joke that the prohibition was in the Constitution in the first place and that we had to get rid of it fairly quickly. They're like, oh, guys, remember when we did that? That was so dumb of us.
It's not. I don't think it should be. I absolutely don't think it should be. The idea that we didn't need to reset our national relationship with alcohol is I think incorrect. Reasonable minds can differ on this, but the way that people consumed alcohol in the 1850s would make Don Draper from Mad Men just shocked. The way that people were consuming specifically hard liquor, which really saw its advent in the 17 and 1800s as a byproduct of agricultural production, sugarcane, corn, and barley. And the way that it had a disproportionate impact on women. It was a women's issue. The women's Christian temperance movement was a movement because women were the victims of men's abuse of alcohol. It led to spousal abuse, family abandonment, unemployment, and really the only way to change that, as seen by activists at the time, was a constitutional amendment.
And to this point, the reason that it needed to be a constitutional amendment was because of the unflinching, inflexible interpretation of the Commerce Clause that the Supreme Court had handed down. Like,
yes.
Like today, for example, 2024, regulations on alcohol are so much more strident than they were in the pre-prohibition period. Like, did we need to fully ban alcohol? No, we didn't need to fully ban alcohol, probably. Hindsight's 2020, right? But if we had the ability to pass the kinds of laws that exist today for the sale and manufacture of alcohol, then we probably wouldn't have needed to do the constitutional amendment anyway. And this, I think, speaks to, unless Megan has one more thing to say on this point, the last bit that I want to bring up here, which is, yes, we want to get more comfortable with changing the actual text of the Constitution, but we should also be more comfortable, I think, with the living Constitution as a judicial philosophy. Lots of people have this idea that originalism is original because it sounds like it came first. But as those of you who are watching this can see, Megan is shaking her head.
Absolute PR job.
Like, yeah, complete and utter PR coup. Like, originalism is like 50 years old, max, basically. It is an invention.
A response to the Warren Court, among other things.
It is an invention of the conservative legal movement. And so I think part of this is moving away from this public relations coup that originalism has had and convincing people that this is the right way to interpret the Constitution, and moving towards a situation in which constitutional interpretation is more flexible. As Megan said way up at the top, right? Given our institutional setup, given how hard amending the Constitution is, even if we change the culture and change norms around this kind of thing, most of the constitutional change is still probably going to come from changes to interpretation of the existing text. And I have a few examples here of sort of things that I've told my students, in fact, in the past, of like why I find it a little bit difficult to take originalism seriously. The first of these is looking at the Commerce Clause, for example, as we've been talking about. The Commerce Clause essentially says that the Congress shall have power to regulate commerce with foreign nations and among the several states and with the Indian tribes. When that was originally put in the Constitution, it essentially meant that Congress had the ability to regulate interstate commerce. If something was manufactured in Massachusetts and sold in South Carolina, that was interstate commerce, and so Congress could regulate it. But nowadays we have just an entirely different system of commerce, and lots of different types of commerce. For example, the example that I gave to my students is Amazon Prime. Is Amazon Prime engaging in interstate commerce when I watch The Boys or Invincible, or if I buy a movie to watch with my wife? When I ask my students this question, I get both responses. I get shakes of the head and I get nods, right? Clearly, it's not obvious. And yet, basically all the jurisprudence that we have says that, yes, actually Amazon is engaging in interstate commerce. And even self-professed originalists will say, well, let's put ourselves in the shoes of the founding generation. What would they have said about Amazon if it existed when they were drafting the Constitution? And that's not an originalist argument. That's not an actual like textualist originalist perspective. Another example of this, just really quickly, is the Fourth Amendment and vehicle searches. Megan was bringing up earlier, and I'll let her take this. Yeah.
Let's be clear that police, in the way they exist right now, did not exist at the time of our founding. Police, as they exist now, were an invention of the Victorians. This is a completely novel concept.
Literally, like a long time later, like 75 years basically later, is when you get the first modern police forces. Like the idea that there would be some dudes whose full-time job it was to go around enforcing the law is a very modern notion. And so all of the jurisprudence that we have around whether or not you can conduct searches on vehicles, right, coming out of the Fourth Amendment, which says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. All the jurisprudence on that is functionally living constitutionalism, whether or not the originalists think it is, right? And then last but not least, and Megan and I are going to argue about this a little bit, is the interpretation of the Second Amendment. It's another sort of PR coup, essentially. But there's a century's worth of conservative legal scholarship trying to
make fetch happen.
Yeah, trying to get an individual right to firearm ownership into the Constitution.
And I can't believe they pulled it off.
They pulled it off.
They made fetch happen.
In 2008, in DC v. Heller, is the first time that the Supreme Court recognizes an individual right to firearm ownership. A pure originalist perspective absolutely 100% cannot hold that the Second Amendment, as drafted, as written, was intended to confer an individual right to firearm ownership. It's just it's incredibly clear. It's so obvious to anyone who has read the documentation from this time period. It did not mean that. It specifically, and the Supreme Court held this for more than 2 centuries, that it only had to do with weapons that were reasonably connected to militia service.
And of course, lest we forget, these guys were dealing with completely different types of firearms. The idea that you could buy a machine gun I think legally in some states.
The idea that you could conceal a firearm, right?
Yes, firearms weren't concealable. What are we doing? And then the Supreme Court writes itself into a hole, really, when it says that we're going to do just historical tests, basically, to see if something would have been embraced. The idea that you can put someone on a red flag list or a list of people who are not allowed to purchase firearms if they have domestic violence convictions. If marital rape was legal and not a crime, then how can a domestic violence red flag list exist and prohibit individual rights to firearms? It just, you write yourself into a very dangerous spot very quickly in terms of what we want social outcomes to be. But during the break, Clayton, we talked about this, and my position is very strongly that if advocates want a individual right to own firearms free from any state infringement, they have a way to get that for themselves. And the way that they get that for themselves is, say it with me, my friend, amend the Constitution.
And my perspective, and this is what we're going to argue about a little bit, maybe argue, I don't know, is that if you are an adherent of the living Constitution, which I also don't really consider myself a living constitutionalist. I think people, as I said 20 minutes ago or whatever, people are making decisions based on the policy outcome they want.
You're a judicial realist.
Yes, I'm a judicial realist. But if you are an adherent of the living constitutionalist theory, the living constitutionalist school of thought around constitutional interpretation, you have to hold that nowadays, at least, as a result of the evolving jurisprudence, the Second Amendment does confer this individual right to firearm ownership.
I resent needing to reward Wayne LaPierre for his bad behavior. Not into it.
But this is the broad strokes of what we're talking about, is that both of these avenues, actually physically amending the Constitution, as well as allowing the Constitution to be flexible, given evolving interpretations of what the law ought to be and what things mean in a new societal context from the one in which all of these amendments were originally passed, those methods of constitutional change are necessary. And right now, what we're doing, as Megan said, is writing ourselves into smaller and smaller corners where some tiny bit of constitutional flexibility is left, and it's just not sustainable. It won't. Yes. It's not sustainable. It cannot last. It cannot last forever.
Yes, I would add that it jumped out to me while I was doing the research for this episode that the other time that we see no amendments in the way that we see no amendments now is from the 1810s to the 1860s.
And we all remember what happened in the 1860s.
And I'm not trying to be a second Civil War doomer or anything, but
the FBI is literally already on their way to your apartment.
You know, they're not going to find anything interesting. It's fine. But I would say that when we lock ourselves into that rigidity, there is no good outlet for people who are advocating for change or for people who need to actually see that change realized. So I would, just to kind of wrap us up here a little bit, if we reject the norm that the Constitution shouldn't be changed, that we should not be amending the Constitution, and if we embrace constitutional amendments, we need to be prepared for additional challenges when advocating for change, because we aren't just fighting for the substance of the change we want to see, but also against that norm itself. And I think it's entirely possible that we see counter arguments that if we push through progressive amendments, then conservatives may be pushing through conservative amendments. Like I just said, do you want an individual right to own firearms? Write yourself an amendment, etc. I think that the level of difficulty of a constitutional amendment at this point actually works in favor of advocates for constitutional amendments and against those people who are concerned about what might happen if you let that genie out of the bottle. State legislative control is pretty evenly split. 3/4 ratification of anything seems to indicate to me that an amendment would be very broadly supported. Again, I refer you back to the 24th Amendment, which prohibited poll taxes and was ratified in its initial ratification process. So the number of states it took to get to 38 was ratified by Florida and Tennessee, both of which were members of the Confederacy. So while one might argue that the amendment process should be easier, I think that 2/3 of states ratifying would be sufficient. And that the ratification gives a lot of minority power, by which I mean like opinion minority, political minority, not racial, ethnic, etc. Only 1/4 of states at the moment need to oppose something for it not to be included in the Constitution. And given how strong geographic sorting is, that may really make it difficult to amend the Constitution. We might so consider lowering that threshold, but certainly at this point, with the threshold where it is, any constitutional amendment is going to have very broad political support across the country, and that's a democratic idea.
It is a very, what we call in the business, a small d democratic idea. It's
Indeed.
Very popular sovereignty.
Indeed.
And I think that if there's one takeaway that I'm going to have from this episode, and I hope that others take away from this episode, it's that this kind of change is necessary. Like, we can think about the what if scenarios and the potential drawbacks to making this easier, or the potential pitfalls of making the Constitution something that gets changed more often. But I think that the experience of the various states, the experience of other countries, and the scholarly work that has been done on what is necessary for constitutional systems to survive, that we cannot continue. Despite the potential drawbacks of this approach, we cannot continue in this unsustainable, constitutionally rigid way.
Yes.
And it is, I think,
something has to change.
Something has to change. Something has to change. And I think for that reason, it is important that we reject constitutional stasis and embrace constitutional change. But until then, I will see you on the next one. I'm still Clayton Becker.
And I remain Megan Cox.